of music videos, which is actually the sound recording with a with a video attached to it, I believe that this is an error that needs to be corrected in the Copyright Act. And I believe it is one that has been proposed, and that if the Copyright Amendment Bill goes through, RAV will have to be accredited. However, there is another issue. There is nothing to stop any ethical organization from applying to CIPC to be accredited. There is a possibility of voluntary accreditation. RAV presumably either has not thought about this possibility or has thought about it and prefers not to be regulated. I don't believe that the CIPC would turn around to RAV and say, no, you're not allowed to be subject to the regulations of collection societies. I don't think that they would force RAV to work outside of the scope of those regulations.
Yesterday, I asked the question about what you're saying now to the CIPC. And my question was, if I can recall correctly, was whether is there anything that prevents those collecting society, who are not required to be accredited in terms of Copyright Act, to make an application to the CIPC to be accredited. The response that we received yesterday was that, how would you accredit somebody who's not required to be accredited? What's your response to that?
Well, I think that's a nonsense answer, to be quite frank. I think that if they requested to be accredited and to be subject to the regulations, I don't believe that the CIPC could refuse it. Okay. And we also heard from the CIPC that they don't believe that they have any teeth to enforce any of those regulations. So I don't think they would have the teeth to refuse accreditation either, provided that you had more than 50 members, which I believe you have, and that you're dealing in sound recordings, which I believe you are, even though the legislation may say or be vague, so therefore you do not have to apply. I'm not sure, but somebody should test it. Somebody should go to CIPC and say, please, or can we please be allowed to follow the regulations?
You talk about the sound recordings, and that's one of the questions that I'm going to ask Ref after you give evidence. And I'm looking at Section 9. I just want to hear from your view. Section 9 of the Copyright Act.
Yes.
And it provides the nature of the copyright in sound recordings. And if you look at, that's 9. If you look at Section 9, capital A, it does talk about the sound recording rights referred to in Section 9, that if a collecting society is actually collecting for sound recordings, it has to be accredited, if you look at the regulations.
Yes. There is a loophole here, and one that has been well used by ECHO and RAV, to say that where you have an audio-visual application, it becomes a synchronization issue. And therefore, you can then separate the sound recordings from the requirements of a sound recording. And so therefore, if you add a video to it, the sound recording is no longer regulated. And that, I believe, I'm not a lawyer, but we have a lot of entertainment lawyers sitting over there, and they could perhaps tell us. But it is certainly an error, I believe. There was no intention when this was written to say RAV and ECHO don't have to be regulated. I think it was an error, and that's all I can say.
Chair, I wanted to check whether you want to take a break. The next set of questions will go into the prior request. I'm not sure whether you want to take a break for lunch, and then we can then proceed after lunch.
Yeah, we can take a break, but let us be here all at 2.
Okay.
So it will be a short...
At 2?
At 3, sorry, at 3. At 3, sorry. At 3, so it will be a short...
Yeah, I'm coming closer to the end of the
yes,
hearing.
please.
Okay, thank you.
see the
I
silk.
didn't make it a tree. But then it's
Hey? Yeah.
It is in fact not a definition.
ene e se godile wa bona kopana le Oscarala
Yeah, no.
Hello?
Okay, thank you, Chair. I'm going to proceed now. The next set of questions will deal with the actual PIA request. I'm going to refer you to paragraph 27 of your statement, where you're dealing with the PIA request. So maybe perhaps let me refer you to the PIA, the actual PIA request form that you've completed. Yeah.
It's in this one.
Yeah.
Where is it?
Chairperson, while they're checking the PAIA request, I'm not going to go to the form now, but I wanted to go to section 50, subsection 1 of PAIA. PAIA. Section 50, subsection 1 of PAIA. I'm going to read it on record. This is the section that deals with the right of access to records of private bodies. So you know PAIA is drafted in a different way with other legislation. So section 50, subsection A provides that a requester must be given access to any record of a private body if, one, that, and maybe before I proceed, let me just qualify why I'm reading this section, because if you remember yesterday, Chair, in my opening statement, I referred to a recent judgment which they developed about 3 principles about the PAIA, and they said those principles that I've read. But section 50, subsection 1 says a requester must, and the legislator used must, be given access to any records of a private body. But there are conditions upon which an access must be given. The first one, Chair, is that if that record is required for the exercise and protection of any rights. Since we started the evidence with the complainant, all the questions that I was asking was related to establishment of the rights that they need to exercise. So I will go through each of these conditions as we wrap up the evidence. And then B says access must be granted if the person, which means the requester, complies with the procedure requirement in this act relating to the request for access to that record. So there are processes that need to be complied with when you do the request, and then if you comply with those, you'll be granted. And this is very important. So it's not all. So all 3 requirements must be met for access to be granted. So the last one is access to that record is not refused. So it means a private body must grant access to records must be granted if access to that record is not refused in terms of any grounds of refusal, as contained in Chapter 4. So Chapter 4 contains the ground of refusal, and the court has emphasized in the recent judgment about that access to information may be refused only on those conditions. So those are the 3 requirements. Chairperson, I'm going to add the 4th requirement, which is not in this section. And I hope I've got my POPIA Act here with me. Is it here? I can open the soft copy. But for record, it's section 23. It's section 23 of POPIA. Section 23 of POPIA provides for access to personal information. It provides for access to personal information. And I'm just going to read 23(1). It says access to personal information. It says a data subject having provided adequate proof of identity has the right to request a responsible party to confirm free of charge whether or not the responsible party holds personal information about the data subject. But the correct subject paragraph that I want to refer you, Chair, is 23(1)(b), where it says the data subject has a right to request from the responsible party the record or a description of the personal information about the data subject held by the responsible party, including any information about the identity of all third parties or categories of the third parties who have or have had access to the information within reasonable time at a prescribed fee and in reasonable manner and format and in a form that's generally understandable. So if you go to section 25 of POPIA, it then says provision of section 18 and 53 of POPIA applies to the request in terms of section 23. If, Chair, you go to section 18 and 53 of POPIA, this is the process where you do the POPIA request. So that's why I added the 4th requirement under access to personal information. The requirement is that adequate proof of identity is the 4th one that I've added as a requirement under section 50. So the question that I'm going to ask will be on those aspects. And this deals exactly with whether the regulator should, whether access should have been granted or not. Thank you, Chair. So if we may proceed, so the first inquiry, as I've indicated, is whether the records in which access has been sought is required for the exercise and the protection of any rights. And the first question that I have is that you have submitted that you require access to those records that you read on record, right? And the question is, are any of the records in which you seek access relate to Bula Records' rights to royalties prior to the sale agreement?
Sorry, say that again.
You earlier on, you specified the records which you require access to.
Yes.
And the question that I'm asking you is that, are any of those records in which you seek access relates to Bula Records' rights to royalties prior to the sale agreement? And Section 53 of PAIA, this is just a statement, I'll ask you a question, provides that a requester contemplated in subsection 1 include a request for access to records containing personal information about the request. In other words, you can actually request your own personal information. That's what Section 50 subsection 3 says. So I will now refer you to Section 23. I've already read the Section 23 that in which a data subject having provided adequate proof of identity has the rights, and those I've already referred you to. Exactly which rights do you want to protect or exercise? That you already indicated the rights to royalties that you provided,
Yes.
right? But please explain to the chair why you cannot exercise or protect those rights without the records that you request access to.
Okay. As far as collection societies are concerned, and I think this was raised in previous witnesses, the rights or the records are contained in private databases. In other words, there's no central registry of these rights. So what typically happens is that SAMPRA will have their own database of these rights. If we look at SAMPRA's database, for example, it doesn't contain ISRC codes. And in fact, if you look at other databases like PPL in London, for the same repertoire, it contains different ISRC codes, and in fact, Thank you. So what you have is you have multiple private databases, and they are not all the same. Some of them contain different information or put in different ways. We've seen this before, and it was raised before, where one work can have several different entries in the same database and in different databases. And if you do not have access to those databases and that information, it is not at all possible. You cannot go to the person who has collected those rights and say to them, please pay me because you've received X amount of money, because you don't know what they've received, when they received it, and on what basis it is. Now, if you have a civil claim against somebody that has claimed money that is not due to them and is due to you, but you don't know what was paid, when it was paid, what it was paid for, it is impossible to lay any kind of claim. And in fact, you cannot even lay criminal charges against anybody if you don't know what they've been paid, even if they have fraudulently claimed money that doesn't belong to them. You simply cannot do it. And if you then want to exercise your rights, and the bodies that hold that information are not prepared to provide it to you, in fact, the only resort you have is to follow the criminal justice route, which means that you then have to go and lay a complaint, you have to ask the police to investigate it. They have to go through that process. And if that body doesn't provide the information, they then have to subpoena it, I believe, in terms of Section 205 of the Criminal Procedures Act. Now, we know, and you asked a question earlier, has anybody ever tried this? And the answer is yes. I have a matter registered in the Hillbrow police station on one of these matters. It's been going on for 2 years. No charges have been laid, no charge sheet has been, and none of the parties involved have provided specific records relating to what royalties were paid. So the answer is, if you do not have it, you cannot exercise your rights in any shape or form. You cannot follow a civil process or a criminal one. Neither of those are open to you without that information, which is contained in private databases. So the only option that would be open would be an enforcement notice from, say, the information regulator that then requires people to provide this information. And once the information is provided, the story is not over yet, because you then have to then still follow a civil process, or a criminal process, I suppose. You still have to go and sue that party for the money that they've received on your behalf. But the information has to be the first step. If you don't have it, you can't do anything.
Thank you. The next set of questions that we're supposed to check as the regulator, I've dealt now with the issue of the rights to be exercised and that the records, the response that we got. Now the person needs to be complied with the procedural requirement of PAIA for you to be granted access to the records. So hence I ask you to check the form that you have submitted, the PAIA request. So the question that I have is that there's a PAIA form that earlier on your evidence is that you did submit a PAIA request form.
Yes.
And that's the form that we submitted. And I wanted to check, which form did you submit? Is it from
It says
on top there?
J752, Form C,
Form C.
Yes.
When did you submit it?
1st of April 2021.
Okay, Chair, the reason why I'm asking that question is because PAIA was amended and the regulations prescribe a new form. But those regulations were only promulgated on the 29th of August. So the PAIA form applicable at the time before 30th of June 2021, it was the form that he submitted. That was the form that was applicable.
Yeah, I remember before PAIA got amended, it was either Form A or Form B. The other one for public body.
I think it's BNC. Is it BNC?
Yes.
Yeah.
Now there's a new form after the 30th of June, that last year when you took the PAIA mandate, but
Yes.
you couldn't have used that form
Because the regulations were not in.
Yes, I understand the point.
Okay, so so it doesn't end there in terms of procedural aspect. The other aspect that we need to look at is whether the PAIA request was submitted to a private body, to the head of the private body.
Yes, it was.
Who, if it was, who responded to a PAIA request?
I think I'm being silenced. Right, so can you hear me now?
Yes, we can hear you.
Okay. So initially, when we had the discussion with the chairperson of RAV, I wrote to her, it was suggested by Advocate Sabisi that I file a PAIA request. I then wrote to the head of RAV.
Advocate CVC is the CEO of REV.
Yes, and of RISA, yeah. So we had a meeting where Advocate Sabisi indicated that he did not want to give me the information because he believed that it would create a dangerous precedent. And we have this on record. And in addition to that, he made it clear that he personally did not want me to get the information because he had, together with RISA, had already instituted litigation against me for defamation in the amount of 3.5 million rand, and he felt that this information was somehow linked to that defamation claim. So on that basis, I asked that he not be the person that adjudicates this because it would be impossible for him to be impartial. He then told me that Mr. Nishal Lala was the information officer in this case, and I submitted the documents to Mr. Lala. Thereafter, once they had been submitted, I was then told that the information officer was changed and it had gone back to Advocate Sibisi in spite of my request that it not be him. And he then told me that Mr. Lala was the receiving officer only and that he wasn't the actual information officer. So I'd submitted it to Mr. Lala as the receiving officer, and Mr. Lala would also confirm this because he was in the email chain. And so what happened was it bounced around a bit, but it ended up with Advocate Sibisi being the person that would adjudicate this in spite of the fact that he had already made it extremely clear that he did not believe I should be given the information even before getting the request, and that one of the reasons, and he didn't explain why it would create a dangerous precedent, and he didn't explain why he believed that this information was relevant to the slap suit that they had pounded me with about 6 months or 12 months before. I might like to add that the issue as far as the slap suit is concerned is absolute nonsense because the Advocate Sibisi, who has claimed over R1 million in his personal capacity as damages, has not bothered to bring this to court. However, it has cost me several R100,000.
You just need to...
Sorry, it has cost me several R100,000 in legal fees to date. Can I object to Mr. Sibisi acting as a legal representative when the procedure says he may not?
Chair, I must object on behalf of my client. Mr. Hardwick, or this witness, is putting certain allegations as if they are fact, when he knows fully well that they are not true. And these are issues that I don't think it is proper for us to ventilate at this forum. Because if called upon to do so, we will do so, to demonstrate that this witness is misleading this forum and is actually grandstanding.
Chair, I do agree that we shouldn't venture into the criminal process. So I want to request that we stick to the question that I've asked you about. Who actually did you send the PAYA request to?
I sent it to Mr. Nishal Lala.
Okay, I just wanted to confirm I've got the PAYA manual from REF. This is a statutory document that all private bodies are required to have, even in their website. And when you're pronouncing, I could not didn't know who you're referring to, but I've got the PAYA manual. It's Nishai Lila. Is that the person?
That is, yes.
Okay.
And
No,
can I tell you that I requested the PAYA manual and I didn't get it for several weeks. The PAYA manual was only given to me after the decision that Mr. Lala would become the receiver and not the. And I would like for RAV and RISA to give us evidence of when the PIA manual was actually published, because I don't believe that it was, I believe that it was only published after I requested it.
I just wanted to confirm on record, Chair, that we do have a copy of PIA manual was provided by REF. And Nishai Lala is actually, it's recorded as the request liaison officer. I suspect that this is deputy information officer because PIA doesn't provide for a request liaison officer. But I suspect Nishai Lala was performing a deputy information officer duties. That's what I suspect. But in the PIA manual, it's recorded as a request liaising officer. Just want to go back to my questions as well. So you said you submitted the PIA request to what they call in REF is a PIA, a request liaison officer, which in terms of PIA is a deputy information officer who is allowed, or actually who have got a statutory legal obligation to accept the PIA request in terms of PIA. So when you submitted this and it was received by the Deputy Information Officer, who responded to your PIA request?
Mr. Lala responded to the request, and after responding to the request, it was only after that he provided me with the manual. The manual was only provided to me after I submitted the request, when in fact I'd asked for the manual well before that date.
No, my question is, once you've submitted your PIA request, you did receive a response from REF to your request.
Yes, I did.
And who actually responded to your PIA request?
Initially, Mr. Lala did, and then it then was handed on to Advocate Sabisi.
Okay, we'll go into that response. But lastly, if you require access, is it me? Okay. Okay, thanks a lot. So lastly, in terms of the procedural process, if you require access to personal information, you have to comply with Section 23(1) of POPIA, as I indicated earlier on. You will have to provide adequate proof of identity. What form of proof of identity did you submit to REF? Or maybe before that, maybe my question should be, do you believe the information that you require, it's personal information?
I'm not sure. It depends. It's not personal information to me as personal information, but it's information that belongs to Hardwick Trading. I don't know if that's defined as personal information.
Is Hardwick Trading a juristic person?
Yes, it is.
It is a person in terms of POPIA.
Okay.
Okay, so the form of identity which you provided to REF, what form of identity did you provide to prove that you are actually the rightful person who required the information that you require?
I filled in the form as required, and I don't remember seeing anything that required me to give proof of identity.
Did you submit any documents to confirm that indeed you have the rights to request for the information that required to the board, to REF?
No, I provided the identity number of the company, Hardwick Trading, and on that basis I would believe that if there was any doubt as to whether the company existed or not, that could have been verified. But I wasn't asked to provide any proof that Hardwick Trading existed, if that's the question.
So you were not requested to provide a proof.
No, I wasn't.
Okay, I'm going to take you through to the response that you have received. You do have that? Do you have it? I can actually give you, it's fine if you can find it. He has to read it on record. Is that the response that you have received to your prior request?
Yes, it was an email from Advocate Sabisi.
You have indicated there on that Advocate CVC is actually the head or the CEO of REF.
I believe that to be true, yes.
And he's the one who responded to your prior request.
That's correct.
Can you please confirm the date in which you received that response?
The date was the 26th of April, 2021.
Do you recall when you filed your prior request?
Yes, it was on the 1st of April. So
So-
he responded within the 30 days.
Okay. And what was the response? Can you read the response on record?
Dear Mr. Hardwick, I've considered your request for information dated the 1st of April 2021 and confirm that your request is hereby declined for the following reason. Failure to provide a valid assignment of rights from Buller Records to Chieftain Family Trust.
If you can stop there. Firstly, your request for access has been declined.
Yes,
And the second thing was the reason for declining.
yes.
Can you just read again the reason for declining?
Failure to provide a valid assignment of rights from Buller Records to Chieftain Family Trust.
Earlier on, I asked you if you did submit anything to REF regarding anything that can provide adequate proof that
Yes.
you are representing them.
Yes, I was asked for proof that this assignment had been made.
Did you submit the assignment?
I did.
Is it the assignment that you provided evidence on earlier on that has been from Chieftain to Hardwick Trading?
No. Yes, well, that is the case. But he declined it on the basis that there wasn't a valid assignment of rights from Buller Records to the Chieftain Family Trust. He did not decline it on the basis that Hardwick Trading was not assigned the rights. He did it on the basis that the Chieftain Family Trust had not been, there was a valid assignment of rights to the Chieftain Family Trust. So the request came from Hardwick Trading, and it was declined on the basis that he did not believe that there was a valid assignment to the Chieftain Family Trust, which was not the company that had filed the request.
Earlier on, you provided evidence that Buller Records had two shareholders.
Yes,
And you said one of the shareholder is Chieftain Family Trust.
that's correct, and that is verified in the sale of assets agreement. The shareholders were noted in that agreement, and that agreement was drafted by Times Media, and it was drafted by their attorney, who went to our company's auditors and secretarial company to verify who the shareholders were. After verifying it, the sale of assets agreement was drafted, and it lists Chieftain Family Trust as the shareholder, or a 50% shareholder.
You also given evidence that since there was two shareholders, the Chieftain was one of the shareholders. I ask you a question about the rights that you are claiming are the rights that supposed to accrue to Chieftain Family Trust, and you said yes.
That's correct.
And the other rights, the shareholder will have to claim those rights separately.
That's correct.
You also provided us with a session agreement, assignment agreement,
Yes,
that was signed by Shipton Family Trust. You said you provided that to Rev.
I did, yes.
Did they indicate to you the reason why that assignment document is not acceptable?
No, they didn't.
So-
And they didn't really explain any reasons why they believed that the assignment of rights from Buller to the Chieftain Trust wasn't valid. Later, Mr. Advocate Sabisi mentioned that he believed that it had to be signed by all the shareholders and directors, which is, I understand, not correct.
So you did provide that document, but it was unacceptable. Hence, the reasons there is that it's. Can you confirm the reason again?
Why they didn't accept it?
No, the reasons that was provided again, because I don't have that
Failure
document.
to provide a valid assignment of rights from Buller Records to the Chieftain Family Trust.
So the reason for refusing access
Yes.
to your access to information is for your failure to provide what they call a valid assignment.
No, it was, we provided the valid assignment of rights, but Advocate Sabisi determined that it wasn't valid.
Okay.
Although I must say that I don't believe that he is empowered to do so. He is not a copyright tribunal.
Chair, I actually going to kind of like breach the requirement in terms of burden of proof. And I'm going to request an opportunity for him to provide, in terms of the case law that I read yesterday in the opening statement, the obligation to prove that refusal of access to information was in terms of the grounds of refusal. It's on the person who's refusing access, not on the requester. That's in the judgment that we have. I'm going to request the complainant to confirm if he believes, and this is his comment, the grounds that is noted in that email, if those grounds false, I know you don't know, you may not know because